I'm going to start sharing my screen because I have a few slides. So just bear with me a moment when this, until this is done. So I hope now you can see my slides
Yes.
on your screen. That's excellent. So I'm going to speak to you about intellectual property rights and public health in this short presentation. Now, this is a vast topic and I cannot necessarily cover it in all detail. I will focus after a general introduction on the particular current question about access to COVID vaccination. And I will look at this in a way from a global, but also from a national perspective. So in order to begin, maybe the first thing is perhaps to look at this overall interface and to explain a little bit about the interface between intellectual property rights and public health. And I don't know how much you are familiar with intellectual property rights in general. I understand my co-speaker later on is also an expert on IP rights. And I assume that some of you have perhaps studied IP rights to some extent. So this will be then a repetition for you, but others who have maybe not so far yet come across this field of law, let me just explain briefly so that you see the connection between IP rights, in particular patent protection, and public health. So these rights, intellectual property rights, they cover a range of things, including inventions, for example. And inventions, for example, include medicines if they are new, inventive, and can be applied in industry. So these rights are basically territorial in that India, for example, grants maybe patent rights, and then those rights are covered the territory of India, the same maybe with, say, Germany and the United Kingdom. All countries have their own systems of domestic intellectual property rights, but then there is an international attempt to harmonize intellectual property rights in these different jurisdictions. And that is something which has been going on for more or less 150 years now. And these rights basically serve and operate as a limited form of monopoly, you could say, which gives the right owner, say the person applying for a patent, for example, the opportunity to exploit, to commercially benefit from that, say, invention, for example, for a limited time. Usually in the case of patents, that's 20 years from the date from which you have filed for your patent. And in that sense, because they offer this limited monopoly to the patent owner, the patent owners can determine whether they want to license this technology, want to allow others to, for example, produce drugs under against some sort of a licensing fee, or they can keep that for themselves and maybe introduce products onto the market. So you can perhaps easily see that these limited monopolies, as they are sort of, monopolies, in fact, have the potential to impact on access of the maybe drugs or other types of products protected by intellectual property rights. So the fact that we have these rights can, in principle, serve as a problem in terms of being able to access, for example, drugs, and especially they can also affect prices for medicines and other types of products protected by IP rights. And so one might wonder, why would one want to have these kinds of monopolies in the first place, as they are somewhat counter to competition and free trade? And then that is often the sort of balance or the basic question you're confronted with in the area of intellectual property rights. The basic argument for having these rights in the first place is to say, well, they serve as incentives for private actors in a market environment primarily to invest in research and development, in new technologies, in innovations, in new cultural products, and so on. For example, of course, including new drug developments, new medicines. And without these incentives, without this possibility of having some form of a limited monopoly, most private market actors, most companies perhaps would be less interested to actually invest huge amounts, especially in certain areas like, again, medicines, to come up with new drugs. So the basic idea is that these rights essentially are a necessary tool to facilitate overall welfare. Whether they actually do this is a different question. and is a question which probably cannot be answered in general, because it will depend on the type of industry, it will depend on the different national context. Some countries have benefited quite a bit from having intellectual property rights and maybe strengthening intellectual property rights. Other countries, in fact, have benefited quite a lot from not having intellectual property rights. So there's always a debate about whether IP rights are a good thing, and if so, how much protection should be afforded, should it be afforded in all countries to the same extent, and so on. And you can see that perhaps from the perspective of those owning IP rights, think especially about major globally operating companies, they will definitely have an interest in having as uniform as possible protection of these rights across the world, at least in the main jurisdictions where they're operating, in the main markets. But from the perspective of the countries, the individual countries and maybe local constituencies, users and maybe competitors in individual countries, it may be not so clear that this protection should necessarily be always afforded to the same extent. So this is the basic paradigm we have in IP law, that there's an idea that these rights are useful to incentivize new innovation and overall benefit society. But on the other hand, there's also the argument that they significantly affect access and especially affordability of particular important products, including medicines. So that's always a contentious issue, and we can perhaps discuss later on how that works out with regard to India in particular, where probably you are more expert than I am. Now, I want to briefly touch on a range of issues with a particular focus on access to COVID vaccinations. So my main argument is to say that in the short term, I would say this year and perhaps next year, IP issues are not going to be the main inhibitor to access to the vaccines, because I think the main inhibitor for the foreseeable future of this and next year is manufacturing capacity, the ability to make these vaccines in large quantities, and perhaps also questions where they're being made, and countries which don't have sufficient domestic manufacturing capacity, perhaps not having sufficient access to these vaccines. And you already see that now when you look at very recent disputes emerging in Europe. And then, however, in the mid to long term, I would suggest that intellectual property rights, different types of rights, but primarily patent rights, plus some other forms of protection which are called test data protections, can definitely have impact on access to the vaccine. And then one has to look at it in terms of how these rights exactly look like on the national level. That's the first point here. And that, of course, depends. One can just sort of look at different examples, perhaps, and different countries providing different types of protections relevant for COVID vaccines. But the second step then is perhaps to look at the international level and see what countries would have to do and what options countries have to perhaps specifically facilitate and make access to vaccines easier, and what limitations to these options exists in international agreements. And that's my main area, basically, so I'm going to say a little bit about that. Lastly, I'm just going to finish with some sort of an outlook and a critique, and that's sort of the agenda, and I'm going to try to do this in the next 15 or so minutes, because I understand that the talk is not meant to be much more than 20 minutes, and I think I've probably already run a little bit over time. If you at any one time want me to sort of wrap up, please just intervene and let me know, that's fine. Okay, so to begin, if we look at the short-term issues, I would say that questions about access to COVID vaccines are mainly questions of technological capacity and manufacturing capacity. If you look at the different vaccine technologies which are at issue, and of course there are different ones, I'm just focusing on two prominent examples. You have messenger RNA vaccines and you have modified flu viruses vaccines. And I think in both instances, the technology operating to actually, produce that vaccine is significantly advanced and requires high-level technological capacity in order to be actually able to produce these vaccines. And it's also not so much a question of simply being able to, from the information, for example, about what exactly a particular vaccine does, being able then to produce it at mass scale, because that often will also require further information about the exact production process and so on. So without actually being told by the companies who have designed these vaccines in the first place how exactly to produce them at large scale, it's going to be difficult for companies, including generic companies, perhaps to simply replicate, reverse engineer, or copy that. So that's therefore, I think, a key limiting factor in the short term. And of course, also taking even into account licensing and the ability of the companies like Pfizer-BioNTech on the one hand and Oxford-AstraZeneca, just to name two major vaccine producers and IP owners on this. They have, to some extent, licensed their technology and have allowed others to produce them. However, that in itself is also just a question about how much production facilities and manufacturing facilities do you actually have to make these vaccines. India has quite significant facilities. I know, for example, that the India Serum Institute has an arrangement with AstraZeneca to produce, I think this year alone, 100 million, maybe more, doses of the Oxford AstraZeneca vaccine, and similar deals are in place with companies in Mexico, Argentina, and Brazil, and elsewhere around the world. So nevertheless, I think manufacturing capacity is going to be a key, if not the most important limiting factor. And unfortunately, and that was probably something also to be expected, if you look at how countries, especially rich countries, have behaved in the last 6 months or so, you see that basically for the amount of vaccine which can be produced, especially from the Pfizer-BioNTech, Moderna, and the Oxford-AstraZeneca vaccine to some lesser extent perhaps, but especially the mRNA vaccines, they have been basically bought up to more than 80% by rich countries. And they have entered into these advanced purchase commitments where countries like Canada, UK, the United States, the European Union, and others have tried to get their hands on as much as possible on these vaccines. It's a bit better when one looks at the Oxford AstraZeneca one, because that is, for example, made, as I said earlier, in large scale also elsewhere in the world. And other countries have access to that vaccine as well. And then there's a World Health Organization program called COVAX, which is meant to serve as a sort of pooled purchasing facility where countries can pool their money together to purchase vaccines. But to be honest, I'm a bit skeptical. One will have to see how it actually operates, so I don't want to speculate too much about it. But it seems to me, or at least some have criticized this, for perhaps only being, making vaccines available at a sort of lesser amount to poorer countries. The availability is going to be capped at 20% of the needed parts of the population of any given country through this COVAX mechanism, and certain countries don't even have sufficient money to put into the COVAX mechanism, and then they are reliant on international donations. So it will depend on how much actually these mechanisms from the WHO are able to afford vaccines to poorer countries. Just to say that for some kind of vaccines, especially again the mRNA vaccines by Pfizer-BioNTech, there's going to be difficulties in actually supplying and administering these vaccines properly, because the Pfizer-BioNTech vaccine, for example, needs to be stored at -80 roundabout until the last 2 or 3 days before it's been actually administered. So that, of course, will be difficult for certain countries where it's really hot and where you don't have these extreme cooling facilities. So this is, I think, in the short term, therefore, the main inhibitor to access, namely global production facilities and capabilities and these private contracts, these advanced purchases. I can say about that a little bit more if you have questions about it, especially because there's a recent round now in the UK and Europe where apparently Pfizer is unable to produce enough vaccines for the European Union, and the same goes for AstraZeneca, and they're already asking for production from the UK to be made available in Europe, and there may well be a dispute about that at some point if they can't resolve this in an amicable fashion. Okay, then like moving on to the mid to more long-term impact of intellectual property rights. And here the starting point again is that these rights are of course territorial, as I've said. So it would depend in principle on whether there is a patent, for example, on these vaccines granted in, say, India or in any other countries. And of course, there may be situations where there will not be patents granted on these vaccines. And then one might think, if there's no patent granted, how should there be any impact on the accessibility and affordability? Well, that goes back to the point that many, many countries don't have domestic production facilities. And if you as a country don't have the facility and opportunity to produce the vaccine, of course, you're then relying on importation. And then it depends on whether there is a patent in the country from where you are importing. So if, for example, India as a key sort of country with lots of manufacturing capacity and which has operated basically as the pharmacy for developing countries or for many countries, say in Africa, as we've seen in the HIV/AIDS pandemic 20 years ago. If India would, for example, grant patent protection for many of these vaccines, then that would not only impact access in India, but it would also impact on access in countries which rely on imports from India. So that is how these sort of patent rights, even though they are territorial in nature, can have implications on accessibility elsewhere. And then there are two types of rights which one has to keep in mind when one looks at COVID vaccines. So far, I've mainly really only spoken about the patent protection for medicines, including vaccines. But let me just mention one other type of right, which is not so globally common in the sense that not all countries have this right, at least not in exactly the same form. And this is protection for the data which is produced in order to show the drug administration authorities that the drug, here in this case the vaccine, is safe and efficacious to use. So this data is, of course, very important. You have to run these clinical trials. And yes, for the vaccine, we know that this has all been done in a very short time frame and maybe not as detailed as it would be otherwise been done. And usually these trials take about 8 or 5 years and so on. And so it takes a long time to produce this data. But this data is then protected against anyone else using it. So that means that companies who want to show that their own vaccines are equally safe cannot rely on this data to show that their vaccines are basically exactly the same, a copy of, or more or less at least bioequivalent or biosimilar to the vaccines which have been tested properly. So that means basically that during the period for which this test data is protected, generic competitors cannot enter the market and get approval for their generic copies of the kinds of, say, drugs or vaccines they want to bring to the market. So it's effectively serving as another sort of barrier to access. And in lots of agreements, international agreements, free trade agreements, as they're usually called, lots of countries have accepted to grant 5 to 10 years of test data exclusivity. And if these exclusivity periods are actually made available to these vaccines, then this would mean that there will not be generic competition unless there are other limitations to these test data exclusivities. And that is a question which is a bit more complex and a bit more difficult to answer. So I'm just saying that these test data exclusivity periods also need to be kept in mind when one looks at access to these vaccines. And when we just briefly say 1 or 2 more things about patent rights, then there may be, of course, specifically patent being applied for these new vaccines. And usually the patent granting period takes about, I don't know, 2 to 3 years. but again, probably we'll see this being happening quite faster with the vaccines. So there may be vaccine patents granted for these vaccines in the, in this year even already, or perhaps early next year, we'll see. But then once the patent has been granted, there will be again this sort of monopoly period, as I mentioned at the beginning, and that can of course have implications for access. But in addition, you also have to keep in mind that existing patents might be relevant for certain aspects of the vaccine technology, especially this messenger RNA technology has been subject to quite a range of patents already. So in that sense, one also has to keep in mind existing patents. But of course, all of these patents, right, can be limited, and that's where I'm coming now to the international level, because countries can, if they want to, and the international system allows them to, including the TRIPS agreement. This is the agreement on intellectual property rights in the WTO. They, on the one hand, have to provide patents for all fields of technologies, including product patents for pharmaceuticals. That's something India, for example, had to change in 2005, and it did so. But at the same time, while you do have to provide these patent rights, you can limit these patent rights in various ways. And compulsory licenses are one particular way to do so. This is basically an idea that you force the patent owner to grant someone else a license to produce the patented product, for example, the vaccine. But of course, it only really works if someone else is able to, also produce that particular vaccine, has the technological capacity. So again, many countries don't have that, and these compulsory licenses therefore only really work in countries, perhaps like India, which have the capacity to produce these vaccines, right? So if countries don't have sufficient manufacturing capacity, then the international system allows some sort of a bilateral mechanism that, for example, India could produce for another country which may have not sufficient manufacturing capacity, these vaccines, and export them to that country. And that country would then be allowed to sell and domestically distribute these vaccines. So there are mechanisms for this purpose, but some of these mechanisms involve quite a bit of red tape and administration, and so they may be seen as perhaps somewhat difficult to use, especially in times of emergency like the current pandemic. And then when it comes to this test data protection, which I mentioned just earlier, this is also addressed on the international level, not only in these free trade agreements I mentioned earlier, but also in the TRIPS agreement itself, although the amount of protection required under the TRIPS agreement is perhaps not exactly clear in terms of what countries actually have to do, because they only have to protect against unfair commercial use and disclosure of this data. And that is, again, perhaps subject to a range of limitations, especially their national security exceptions under the TRIPS agreement, which countries could probably also rely on in the current context of a pandemic. So my, I think, main message here is when we look at the international system, the system does provide for certain flexibilities, which hopefully should allow but we will have to see how it actually works out in practice in the next years, but which should allow countries, especially by means of compulsory licensing, to actually facilitate access. But again, the main question I think here is, if you introduce these limits like compulsory licenses, will they actually allow maybe a generic company to produce under the compulsory license? And does that company have sufficient knowledge, expertise, and technological capacity to actually produce these very complex molecules or these synthesized genes in the case of the messenger RNA vaccines? Right, my last point then is kind of a critique and looking ahead. Now, you may have heard that in the global discourse about COVID and vaccines, there's always been this saying about no one is safe until everyone is safe. And I'm just wondering whether, if you look at how the rich countries have behaved and have bought up so many of the vaccines, whether that is going to be true, in fact. I mean, we might think that, yes, these vaccines, of course, really only help as soon as everyone is vaccinated around the world. But we also have to, and that I think so far, at least with the major vaccines, this is still an open question. We also have to consider whether the vaccines actually prevent transmission, or whether they only prevent the individual having the vaccine against getting really ill with COVID. Because if they don't prevent transmission, and that's something I think which is still somewhat open, then of course only the person having the vaccine will be actually protected. And then rich countries might, who knows, not be too interested in making sure that everyone around the world is being properly vaccinated. But I think this is still an open issue, and so we'll have to see about that. And I think the main point of critique from my side would be that in the short term, I think there has been no real sort of global community effort, no real fairness in trying to share the vaccine equally. And some countries have bought up 5 times the amount of vaccines which they actually need for their own population. So I think there's a need to perhaps look at this. And there's one example where exactly like this happened before in the context of the H5N1 virus crisis. So this is an influenza virus which was thought to be very problematic a couple of years ago. And there was a particular drug produced by, I think, Roche, a big Swiss pharmaceutical company called Tamiflu. And that was bought up again by the rich countries. But later it turned out that this drug didn't really help at all. So they spent huge amounts of money on buying very large stocks for this drug, but then it turned out not to be too helpful, at least from the reports I've seen. And then just to say 2 more points before I close, I think overall here you see perhaps the need to rethink in a way how the international intellectual property system works. And that's kind of my own sort of take on this. This is my own evaluation of the situation, where when we look at the international IP system in the last 150 or so years since we have put it into being, so since we have international treaties on intellectual property protection, we've really only focused on coordinating protection and making sure that countries agree to protect things under certain circumstances and to a certain extent. And we have always left the limitations and limits of this protection up to the national countries to decide. And that's perhaps in one way a good thing, but if we have a global problem which we want to deal with and where we want to ensure global access, then we also have to coordinate and harmonize the limits of intellectual property protection, or at least the way how this system can facilitate access. And that's something which we probably have to look into a little bit more, including, for example, trying to find mechanisms to facilitate especially voluntary licensing of this technology, the vaccine technology. So I'll close with that. I thank you very much for your attention, and I'm happy to answer questions later on. Thank you so much.
So this is an extremely important, very vital topic, because today, almost every legal system, including India, is talking about data privacy. So when it comes to the healthcare sector, so this is one sector that delivers a service which is very, very crucial and also considered as essential service to the mankind. So therefore, when regulatory framework will have to be designed, we need to keep in mind the interest that conflicts with each other. While on one hand, law should ensure that there is no unnecessary extension of regulation on these professionals who deliver service, which is crucial to life. At the same time, the individual rights, especially those who receive service, so their right, especially including right to privacy, is something that needs to be balanced. So let's see how this attempt is being done in our country. The most relevant law that I would want to focus on, which is relevant to this theme, is Information Technology Act, because that's the one law which, as of now, currently and directly deals with data privacy in general, including data privacy in relation to data that is collected by healthcare workers. The Information Technology Act, which was passed in the year 2000, generally referred to as cyber laws, initially focused on promoting e-commerce and e-governance. But then in the year 2008, a lot of amendments were brought in order to make the law much more wider so that the abuse of this technology, that is cyber technology, could be taken care of. Since this is that technology which provides the platform where a lot of data gets generated, gets transferred, gets transmitted. So there are a couple of sections that also tries to regulate the misuse of data. At the same time, we can also see that there are provisions which provides immunity from liability upon certain stakeholders, including internet intermediaries, as well as upon the corporates. Now, when it comes to corporate hospitals, so they also can avail this immunity. But before we get into the liability imposing provisions and the nature and extent of immunity provided, it is important to note that the term data is defined extremely widely in this particular enactment. So this, on the whole, refers to every information, be it in whatever form it is, text form, word form, video, audio, irrespective of the format in which it is represented, everything that is collected through or processed or possessed through electronic devices can potentially come under the definition of data. And in fact, if these are processed through computers, computer system, computer resources, they get protection through Information Technology Act. It's also important to know that the term computer, computer system, computer network, computer resource are more elaborately defined. So what I'm trying to say is the very concept of data and the data on computer, computer system, they are so widely worded that the law therefore also becomes extremely wider in its ambit and application. And we classify data into various categories, but the most relevant one, especially when you see it, in the Indian law framework, similar to the European. So we classify data mainly into personal data and non-personal data. And in fact, the Information Technology Act under Section 43A, capital A, also has the rules provided under this particular provision. If you go through the definition provided in this particular provision along with the rule, it defines personal data as that data with which a person can be identified, either with that entire data or that data which in combination with some other data is enough to identify a natural person. So basically over here, the one whose right to privacy is taken care of is a natural person, that is of human beings. So which means other data of corporates, etc., it gets protected under another provision which is not relevant for us anyways. So health data also in fact comes under personal data definition, and the same rule further goes on to clarify about another term called as sensitive personal information. However, they do not define the term sensitive personal information, but it gives an inclusive list of data which can fall under this particular category of sensitive personal data. And this includes medical data, health data, or data with which one can know about the sexual orientation of another person, the medical history, etc. So basically that set of data which is usually handled by healthcare workers falls under the category of sensitive personal data and not just personal data. Now, classification of data into personal data and sensitive data is important because sensitive personal data are generally considered as so sensitive and so important that if it's not legally protected, the chances of abuse of this is huge. So therefore, that segregation was essential. But however, if you look at the approach that is adopted by the Information Technology Act, though it uses both the terms in Section 43 and the rules laid down under it, it doesn't give a different approach when it comes to say, legally recognizing this or legally, taking care of this part of data. It just says that if any corporate is handling any personal data or sensitive personal information, the same corporate is responsible to take care of such data. In the sense, you don't take it unless it's necessary, don't share it unless it's necessary, do not transfer it beyond the country unless it's necessary, and even if you're transferring it, ensure that you transfer it to a jurisdiction which also has, if not more, but equal legal protection which is accorded to it in the country. So like this, lot of do's and don'ts are prescribed upon the corporates which handles sensitive as well as personal data. Non-compliance to these rules and regulations, which are actually referred to as rules in relation to reasonable security practices and procedures, or it's also commonly and popularly known as 43A rules. Non-compliance to this is usually seen as negligence, and because of such negligence or non-compliance, if there is a data breach, so that particular corporate is liable under Section 43A. It's a civil liability which is imposed, and such corporate can be made to pay compensation. Earlier law said compensation up to 5 crores, but when we amended the law, we removed the limitation. So now it's like, any extent of damage which, can be prescribed by the court, looking at certain criteria that are fixed, in fact, under the same enactment. It's interesting to note that the enactment initially used the word corporate as the one who could be subjected to the liability under 43A, but then very quickly, within few days, the Ministry of Information Technology came up with a press release clarifying that this section also applies upon individuals. So this would mean that if a doctor or any hospital or a clinic, any institution or an individual who provides health services, and in the course of that gets access to or collects personal data or sensitive personal data, is supposed to take care of it. How? There are three ways through which such data can be taken care of. One is, as I just mentioned, there are rules laid down under the section itself. So either you show the compliance to those rules, which are referred to as 43A rules, or by way of having a mutual agreement between the one who provides the data, that is the data subject to whom the data belongs to, and the company which is collecting, or the individual which is who is collecting the data. So you can have your terms and clauses prescribed through a contract, which means when I go to a hospital, a corporate hospital or a doctor, I and my doctor or the hospital that I approach can enter into an agreement which might have clauses indicating how and to what extent data can be used, etc. So therefore, the way you take care of this particular data privacy can be determined by the contract that both the parties enter into. In the absence of such contract, it is 43A rule which governs. And the third way through which you can protect this data to show compliance to law is by adhering to the rules that are laid down under other laws which are currently applicable in the country for the time being. So these are the words used in the law, which means any law which currently applies. So this is an extremely wider term again, because this refers to any or every law which directly or indirectly imposes obligations upon healthcare service providers to take care of confidentiality and data privacy. So though we started using the term data privacy of recently, but I'm sure we're aware of the fact that the lot of laws which talks about confidentiality requirement, especially to be complied with by professional service providers. Like for example, for advocates, we have Bar Council, which prescribes bar code, that is code of ethics. Similarly, when it comes to say doctors, we have medical code of ethics, and which comes with its own code of the Medical Council of India, which comes with its own code of ethics. And these code of ethics also talks about the duty of the doctor or the healthcare service provider to maintain confidentiality and privacy of the information that he comes across in the course of discharging his duty. So it's wrong to say that we never had a data privacy law. We did have it in one way or the other, and most importantly, in form of medical code of ethics earlier itself. It's just that the kind of sanction that medical code of ethics follows with in case of breach is completely different from what is currently provided by the Information Technology Act. Now, suppose this code of ethics is breached. Of course, the concerned doctor can be held liable as per the Medical Council of India's Act, which allows for suspension of his service, which means that his name can be either temporarily or permanently removed. So this was the sanction which was allowed as per the Medical Council of India Act. Now the current Information Technology Act gets added with this because it says you follow 43A either in three ways, in one of the three ways, and one of such ways as per the law that currently exists, which thereby refers to, in fact, indirectly, Medical Code of Ethics Act. In addition to this, there are other laws which also becomes relevant, and the most crucial and extremely important one, especially when data is in the hand of state or state agencies like government hospitals, public sectors, etc., is Article 21 of the Indian Constitution. Indian Constitution under Article 21 guarantees right to life, and this also includes right to liberty. But it is again very, very important to note that Indian judiciary time and again has repeatedly said that right to life also includes right to privacy. And in fact, very recently in Puttaswamy versus State Union of India, the Supreme Court reiterated the same fact that right to life includes right to privacy. In fact, even though earlier this was said to be the same, so there were a lot of grounds on which right to privacy could be curtailed, including by invoking powers that are vested upon state agencies under CRPC and all. To an extent, even this gets restricted now because of the way the court has now interpreted this right in Puttaswamy case. So in Puttaswamy case, the court says that right to life, which includes privacy, cannot be curtailed unless you have a procedure established by law. So which means that state can collect our personal data, including healthcare, related data. State can use this, etc. But don't use it or collect it in a way in which it breaches our privacy. And even when you are encroaching on this right to privacy, there should be a law which allows you to do this. So basically, it is dependent on another law. So there should be a law which allows the state to collect this data or to use this data, etc. And that law should have a legitimate object to be served with. So therefore, it all depends on the purpose for which you collect the data, and the purpose should be just and reasonable, fair, and all. And then thirdly, that this entire procedure that is set by the law, it can't just be simply some procedure. It is supposed to be just, fair, and reasonable. In fact, the Supreme Court, even in an earlier case, an extremely important case called Menaka Gandhi versus Union of India, had said that right to life, if at all has to be curtailed, it can only happen provided you follow a procedure which is just, fair, and reasonable. So this itself sets a standard, that needs to be complied with when there is an encroachment on the right to privacy, even in terms of, say, using our healthcare records. So, in fact, this is the most important law because this sets as a parameter for all other laws. So tomorrow we might come across new laws, new legal principles, etc., through which maybe somebody would get the right to collect our data, including the state, etc. But if it doesn't fulfill all these requirements indicated in Article 21, Menaka Gandhi's case or Puttaswamy case, the same can be termed as unconstitutional and illegal. So that's about the IT Act. IT Act, apart from Section 43, also talks about protection of any other data. You may or may not call it as sensitive personal data or personal data, but all other data that you would collect, which may not be personally identifiable. For example, maybe in hospitals or even in medical colleges or other nursing institutions, etc., or ICMR, institutions like this, which collects data and then anonymizes it. So you convert the data in a form in which you are now unable to identify an individual with reference to this data is fine. But then that data also gets legal protection because Section 43 of the Information Technology Act very clearly says that downloading or extracting any data without the permission of the owner of such data, or like without the permission of the person who's in charge of a computer, and on that computer you're handling this data, etc. So then he can be subjected to civil liability under Section 43. And parallel to Section 43, we have Section 66 of the IT Act, which imposes criminal liability. So what I'm trying to say is, when it comes to personal data and sensitive personal data, if it's not taken care of and results in breach of such data, it can result in imposition of civil liability. A civil case can be filed for such breach under Section 43. If it's any other data, 43 and 66 will apply, which means you have two parallelly provided remedies available. One is civil in nature, the other is criminal in nature. Now, what if it is the state which breaches your data, apart from Article 21 of the Indian Constitution, because where the right to privacy is declared as a fundamental right, even states are bound to protect this. So apart from Article 21, Section 72 of the Information Technology Act, in fact, says that if any person is authorized under the law to collect your data, and in the course of discharging the duty, collects your data, but discloses its confidentiality, etc., he can be subjected to criminal liability under Section 72, and that includes imprisonment up to 2 years. Now, with reference to, like, say, Aadhaar details, or like maybe the data that was collected in the course of like handling COVID, etc. So suppose somebody collects the data and he's been authorized to collect that data, but unreasonably and without any justification of law discloses that data, maybe to media or someone else. So that person, suppose he's using ICT technology, cyberspace as a mode of collection of this data or for illegal disclosure of this data, he can also be subjected to liability under Section 72. Now, if it is any intermediary, internet service provider, now since most of the medical services are even getting say delivered through online platforms, you have online consultations, other platforms through which data is shared, which is also similar to say personal data or sensitive data or other data. So if there is a data that's collected by an internet intermediary and if he discloses it without any justification, etc., or any other corporate entities, not just internet intermediary, and in the course of say discharging their duty under a contract, collect some data or information and disclose its confidentiality, they can also be held liable under Section 72A. So which means you have a lot of sections under Information Technology Act through which individuals, institutions, government agencies, and the agents on behalf of the government, so suppose they disclose data, can be held liable both with civil as well as criminal liability. So that's about the Information Technology Act and the Indian Constitution and the Medical Council of India. So these are the currently existing laws. Now coming to the proposed law, which very soon might get enacted in India, one of the most important law that deals with healthcare service providers, and talks about their obligation to say protect data is referred to as DISHA. Which is nothing but Digital Information Security in Healthcare Act. So this act also talks about, say, the grounds on which and the purpose for which healthcare related data can be collected, can be used, can be handled, the manner in which this should be handled, etc. And this act also imposes liability upon breach of data privacy. Now, all these laws, be it DISHA or be it IT Act, they also have a saving clause, and that's about acts done in good faith. Now, coming to another important law, which also exempts a person from liability for doing anything in good faith, is Indian Penal Code. According to Indian Penal Code, if an offense is committed, but while say doing an act under necessity, in good faith, or for the benefit of another, such person can be exempted from liability. So I might disclose your data, but if I've done it in good faith only to save another person, something like that, which indicates to be a very reasonable ground, just ground, I can be exempted from liability. So therefore, we need to see like under what circumstance data got disclosed, especially in healthcare sector. This is very, very crucial because sometimes maybe it's an emergency situation, or maybe that situation was such that I had to disclose data and it was only done in good faith without a malified intention. So I get a protection from law. We saw this happening in many cases, and the most important case, which is usually considered as a landmark judgment in this aspect, is Mr. X versus Hospital Z case, in which in fact it was about a doctor who disclosed about HIV status, positive status of a person, to that person's fiancé, because the doctor knew that this person was about to get married to the girl. So only to save her from this non-disclosure and its consequences. So he discloses this status, medical condition of Mr. X to his fiancée. So Mr. X files a case of say breach of privacy and all, but court says no, this was done in good faith. So this is how we judge the case. So even though there is a breach of data, so if it is something that falls under IT Act, so we see whether there's been a compliance to due care and caution, whether you've taken care of say security, safeguards, etc., which you could take care of, especially on ICT platform. It's crucial because this is a platform which is prone to cyber attacks, which is prone to attacks like hacking, malware attacks, etc. So, and no, cyber technology is foolproof because there are possibilities of cyber attacks on this. So I have to just show that I've complied with due care and caution, I've complied with security standards, etc., to get exemption even from civil liability. Exemption from criminal liability, I get it in the name of say good faith if I'm able to show this. So this is one law which is going to come, and that's DISHA. In addition to DISHA, we are going to come up with another comprehensive law called Personal Data Protection Bill, a long-awaited law which India is forcing to get implemented. So the PDP bill or the Personal Data Protection Bill goes another step ahead in classifying data into various categories depending upon how crucial this data is. So because we also hear about the concerns of misuse of this data by some commercial interested institutions. So sometimes some data is used in a manner in which it can affect sovereignty of the country. So therefore, this PDP bill, Personal Data Protection Bill, classifies data especially personal data, into personal data, sensitive personal data, and critical personal data. So when they talk about personal data, they also talk about do's, don'ts upon an organization and institution which is handling such data. And this is wide enough to include even healthcare service providers. Then they talk about sensitive personal information. So basically, they will notify which are this sensitive personal information, though they have a definition. So it all depends on whether it is listed in the list of sensitive personal information or not. When it comes to sensitive personal information, you can share it with entities outside the country, but you're supposed to also have a copy in our country. This is referred to as data localization. And when it comes to critical data, again, they don't define this term, but they say government can declare any data as critical data. So critical data cannot move out of the country, cannot go out of the country. So we have to wait and see when this law gets implemented. Currently, the law is, this particular bill is pending before Joint Parliamentary Committee. They had invited comments by different stakeholders, including internet platforms, individuals, etc. So maybe very soon this bill might get enacted. So maybe in future, the healthcare data will be governed through the provisions of Disha as well as PDP bill. So which allows for data transfer outside the country if it is only personal in nature, which allows for data transfer, but with the condition that a copy of it remains in India if it is sensitive personal information, and which doesn't allow for transfer of data beyond the country if it is critical personal data. And healthcare data is such that it can fall under all of this. So depending upon like how detailed the data is, how relatable it is to an individual, so that privacy becomes an issue, etc. So we'll have to wait and see how this law's final version is going to be. So in the absence of these laws being as on today implemented, so I can say that it is the Indian Constitution, Article 21, with reference to state agencies and its Information Technology Act and Medical Code of Ethics. Along with that, other healthcare service providers, also get subjected to their specific laws, like you have Nursing Act, etc. So all other healthcare service providers, the laws that they come under, definitely will have a clause that talks about a requirement to comply with confidentiality. That itself is wide enough to take care of privacy protection in the healthcare domain. So this is about the Indian law when it comes to privacy protection in relation to healthcare data. Another extremely crucial aspect that we've come across during COVID has been the way the services related to, say, epidemic had to be delivered. So in the course of this, data related to COVID patients were collected, disclosed in public platform. But I would say that, these kind of acts, since at that point of time, we weren't sure how the COVID would affect each other. So it was all in the public interest that this got disclosed by local authorities, government agencies, etc. So those kind of acts might fall under the requirement of, say, under the defense of good faith. And in addition to this, since this also falls under Epidemic Diseases Act. So Epidemic Diseases Act, a very short law, but then it gives a lot of power to state governments to regulate the epidemics. And the power given to state governments are so wide that they could, under those laws, states, they could come with their own state-specific regulations, including how they would handle this epidemic and all, which further includes their rights and duties associated with healthcare data. So though Epidemic Diseases Act doesn't directly talk about data privacy, but in the course of regulating the pandemic, state governments have wider powers, so wide that that can also include rules, like power to make rules and regulations in relation to how you would handle this data related to epidemic. But all of this, as I said earlier, are tested on one line, and that is Article 21 of the Indian Constitution. So this is in brief about the Indian legal framework when it comes to data privacy in healthcare service sector. Thank you.